Adultery in India was based on the notion of patriarchy and male chauvinism. The offence makes a man criminally liable who has sexual relations with a woman who is the wife of another man. But if the husband consents or connives to such an act, it will no longer be adultery. In India, the provision of adultery under the penal statutes has gained controversy since its inception. In fact, the main architect of the Indian Penal Code, Lord Macaulay, was himself not in favor of the incorporation of such section. उनके हिसाब से एक पर्सनल एक्ट को क्राइम बनाना सोसाइटी के लिए अननेसेसरी और अनवारंटेड है और इस तरह के डिसीजंस हस्बैंड वाइफ या सोसाइटी पर ही छोड़ देने चाहिए. It was for the first time that a PIL was filed against adultery. A writ petition was filed under Article 32 by Joseph Shine challenging the constitutional validity of Section 497 of IPC, read with Section 198 of the Criminal Procedure Code being violative of Article 14, 15 and 21. The petitioner claimed the provision of adultery to be arbitrary and discriminatory on the basis of gender. The petitioner also claimed that such a law demolishes the dignity of a woman. Section 497 Indian Penal Code और Section 198 Criminal Procedure Code को पहले भी कई बार चैलेंज किया जा चुका है. For the first time, it was challenged in the case of Yusuf Abdul Aziz versus State of Bombay, where the husband was accused with adultery under Section 497 of the Indian Penal Code. In this case, the constitutional validity of Section 497 was challenged on the grounds that it violates Article 14 and 15 by saying that a wife cannot be a culprit or even an abettor in the case of adultery. A 3-judge bench in this case upheld the validity of the said provision and declared that it is a special provision created for the benefit of women and it is saved by Article 15, Clause 3. In this case also, a petition was filed under Article 32 challenging the validity of Section 497 of IPC. This challenge was based on the fact that the said provision does not provide the same right to a woman to prosecute the woman with whom the husband has committed adultery and hence it is discriminatory. A 3-judge bench in this case also upheld the validity by stating that extending the ambit of this offence should be done by the legislature and not by the court. The offence of breaking a family is no smaller than breaking a house, so the punishment is justified. The court accepted that only men can commit such an offence. Is the provision of adultery arbitrary and discriminatory? Is it true that this provision encourages the stereotype that women are men's property and discriminates them on the ground of gender and is violative of Article 15? Whether denying a woman her right to sexual autonomy and right to self-determination would jeopardize her dignity? Is it true that criminalization of adultery is a legitimate intrusion into an individual's private life? A wife is unable to bring charges against her husband for having an adulterous relationship. It is not illegal for a married man to have sexual relationship with a single woman according to this statute. Even if the relationship is voluntary, only the man involved in the adulterous relationship will be punished, not the woman. Adultery was once thought to be the highest possible invasion of property, since it interfered with the husband's exclusive entitlements. On a reading of Section 497, it is clear that women are regarded as second-class citizens to men, as it notes that there is no offense if the man acts with connivance or consent of the husband. This treats the woman as though she were a piece of property. It treats her as though she were a possession of a man, fully subject to her master's will. It reflects the social superiority that existed at the time the penal provision was incorporated. Women are not prosecuted for adultery, and women cannot sue their husbands for adultery under Section 497, which treats men and women unequally. Furthermore, no offense may be created if the husband of a woman who has committed adultery has given his consent or permission. In simple words, अगर वो आदमी जो किसी की वाइफ के साथ सेक्सुअली इन्वॉल्व है, हस्बैंड की परमिशन ले लेता है, तो वो अडल्ट्री के लिए लाइबल नहीं होगा और उसे प्रोसिक्यूट भी नहीं किया जाएगा. The section is manifestly arbitrary and thus in violation of Article 14 because it lacks an appropriate determining principle to criminalize consensual sexual activity. Article 15 Clause 1 forbids the state from discriminating exclusively on grounds of gender. Section 497 की अगर बात करें तो एक आदमी की वाइफ अगर एक अडल्ट्रस रिलेशनशिप में इन्वॉल्व है तो वो आदमी अग्रीव्ड है, केस कर सकता है, लेकिन वही राइट औरत को अवेलेबल नहीं है. मतलब अगर उसका हस्बैंड एक अडल्ट्रस रिलेशनशिप में इन्वॉल्व है तो वो अग्रीव्ड नहीं है, वो केस नहीं कर सकता. When viewed from this perspective, the crime of adultery discriminates against a married man and a married woman solely on grounds of sex. It has been interpreted several times that Article 21 includes human dignity. Section 497 effectively limits a woman's fundamental integrity by establishing invidious distinctions based on gender roles, placing a dent in women's individual dignity. Furthermore, focusing on the factor of connivance or approval on part of the husband amounts to women's subordination. Therefore, the same offends Article 21. The Apex Court in Puttaswamy v. Union of India has accepted sexual privacy as a constitutionally protected natural right. Sharing one's physical intimacies is a deliberate decision. Shackling a woman's personal freedom and allowing criminalization of consensual relationship is a breach of this right. In fact, एक ऐसी औरत जिसकी शादी टूट चुकी है, वो अपने हस्बैंड के साथ नहीं रह रही और उसकी डिवोर्स की प्रोसीडिंग्स पेंडिंग हैं, वो भी अगर एक ऐसी सिचुएशन में किसी आदमी के साथ इन्वॉल्व हो जाती है तो वो आदमी भी अडल्ट्री के लिए लाइबल होता है. The judgment given by the then CJI Deepak Mishra started with the statement proving that wives are not husbands' property and husbands are not masters of their wives. The section denies substantive equality as it provides that women are not able to give free consent for a sexual act in a legal order which considers them as sexual property of their husbands. Therefore, Section 497 is violative of Article 14 of the Indian Constitution and it also violates the non-discriminatory clause of Article 15 of the Constitution of India. This section also lays strong emphasis on the consent of husbands, which lead to the subordination of women. Hence, it clearly violates Article 21 of the Indian Constitution. A crime is committed against the society as a whole, whereas adultery is a personal issue. Adultery does not fit into the ambit of crime as it would otherwise invade the extreme privacy sphere of a marriage. However, adultery can be considered as a civil wrong and is a valid ground for divorce. The judgment focuses on the fact that women should not be considered as properties of their husband and fathers anymore. They have equal status in the society and should be given every opportunity to put their stance forward. Finally, 27 September 2018 में जोसेफ शाइन वर्सेस यूनियन ऑफ इंडिया के केस में एक 150 साल पुराना आर्केक विक्टोरियन मोरालिटी पे बेस्ड लॉ जिसका नाम अडल्ट्री था उसे हटा दिया गया और उसे कॉन्स्टिट्यूशनली इनवैलिड डिक्लेयर कर दिया गया।